Now we will begin today's webinar. My name is Madison McMahon Ward, and I am the Program Manager for Triage Cancer, and I will be moderating today. And it's my pleasure to introduce today's speaker, Monica Bryant. Monica Bryant is a cancer rights attorney, speaker, and author. Monica is the co-founder and chief operating officer for Triage Cancer. Throughout her career, Monica has provided hundreds of educational seminars, written articles, blogs, and co-authored a book published by the American Bar Association called Cancer Rights Law: An Interdisciplinary Approach. Remember, if you have any questions for Monica, please type them in the Q&A box and she will answer them towards the end of her presentation. So with that, I'd like to turn it over to Monica.
Thank you so much, Madison, and thank you to all of you for joining us for 90 minutes to talk about estate planning. So one of the things about this particular topic is that we recognize it can be incredibly complex because of the legal issues, but also really challenging because of the emotional component. When we boil down this topic to what we're really talking about, we're talking about something that's really sad. So a decline in our health or the eventual death. But the reality is, at some point, it is a given that we are all going to pass away. Now, hopefully that won't be for a long time, but it is in fact going to happen to each and every one of us. So for the next hour or so, we're going to talk about some steps that we can all take to make this process a little bit easier on everybody. So when we talk about estate planning, it can mean different things to different people. I tend to think about it in the broadest terms possibly, which means that when we say estate planning, we're talking about the process to create a plan to ensure that your wishes about the distribution of your property and your health care and caring for your loved ones are carried out in your absence. So that is a pretty broad definition, and I recognize that. Now, I also think that there's a general misconception that only wealthy individuals or older individuals need an estate plan. However, I think most people could benefit from having an estate plan. So when we look just at, the group of people here, certainly Mark Zuckerberg, the creator of Facebook, who I think his worth is over $130 billion, he probably needs an estate plan. Certainly this older gentleman is going to benefit from having an estate plan as he nears and gets closer to end of life. Unequivocally, this family with young minor children needs an estate plan in the event that something may happen to the parents. But also this younger woman who has just finished graduate school and has gotten her first job and now is starting to collect some assets like retirement accounts and savings accounts and potentially property. She absolutely can benefit from an estate plan. I would also argue that these younger girls who aren't 18 yet, but maybe one of them has been diagnosed with a serious medical illness like cancer, could benefit from creating some of the same documents that we're going to talk about today. And while they might not be legally binding, we're going to talk about some other benefits as to creating these documents. I recognize that when I talk about estate planning, a lot of people have feelings of shame that maybe they haven't done enough to plan their estate. But I am here to assure you, if you are feeling like that you are absolutely not alone. There are numerous stories of very famous multimillionaires who have died without wills. I am talking about people like Aretha Franklin and Michael Jackson and Prince and Bob Marley. And we know about that because these people all had giant estates, and when they passed away, it caused legal issues. More recently, we heard a story about the founder of Zappos, which is a huge online shoe sales company. The founder, Tony Heish, who died, I think 2 years ago now, he didn't leave a will. What he chose to leave were hundreds of Post-it notes all over the walls of his home, describing what he wanted to have happen to his estate that was worth hundreds of millions of dollars. and obviously caused a huge legal uproar. Unfortunately, these crazy stories are not unique to the rich and famous. The reality is about 68% of Americans don't even have the most basic of estate planning document, which is a will. So all of this is really just to lead up to the conversation that if this is the first time you are really sitting down and thinking about creating an estate plan, I applaud you for that. You are certainly ahead of many. As I mentioned, I recognize that it can be difficult to discuss issues of mortality and even finances. But creating an estate plan may allow you the opportunity to express deeply held values and key personal preferences. It can also be the best way to protect your family and loved ones from potential fights and arguing and having to make really tough decisions at a time when they're also grieving and emotionally challenged. So in some ways, I think of this as a very loving thing to do for your family. Certainly, there are some financial and tax benefits to creating estate plans, but I think that what often gets left out of the conversation around estate planning is that peace of mind that creating an estate plan can bring to you, that your loved ones will know about your wishes and that there aren't loose ends. And so, I often say that pick whatever reason seems to resonate the most with you and hold on to that. If you are struggling with getting started estate planning, I tend to look at it as the idea that as a very type A individual, planning my estate is my last opportunity to exert control over my loved ones, even after I'm dead. And that was the thing that made it possible for me to get over the emotions behind thinking of my mortality. So again, not all of this is going to resonate with all of you, but sort of find the thing that helps you get through it and hold on to that. For someone who's just starting the process of creating an estate plan, I think that it's normal to feel overwhelmed. Where do I start? How do I even start making these decisions and figuring out what it is that I need? These are just some big picture questions to help you get started. You may not even know the answers to all of these questions, but if you are really starting from square one, start here and just jot down some notes. If you are married, have some conversations with your partner about what do they feel about these particular things to see if everybody's in alignment or if there needs to be more conversations. The next step in creating an estate plan is thinking about your property. An estate is going to include the property that you own at the time of your death, and the components of an estate could be wide-ranging. When most people think about property, they immediately think about land or a house, which in legal terms is referred to as real property. But we also need to include things that aren't physical, like bank accounts and retirement accounts and stocks and bonds and pensions. That all should be as part of an estate. There may also be some things that you don't think of as property, like photographs or emails or electronic devices that have documents on them, or even your social media account. Those are what are typically considered intellectual property. And so anything that you may have intellectual property rights on should also be included into your estate. I also think that many people, when they think about their property, don't always think about personal property. So we're not talking about a house here, but maybe a car or family heirlooms or jewelry or a record collection. Those are also things that could be included in somebody's estate. Now, once you've determined what you own, you may want to figure out what it's worth. For many pieces of property, you could get an appraisal where a professional will tell you how much it's worth in today's market. But when you're thinking about something's value, don't forget about sentimental value. For example, you might have a piece of furniture or an antique camera that has been in the family for a long time, and it may not be worth much if you sell it, but it has great sentimental meaning and value to your family. That could be something that you include in your estate plan. So once we figured out big picture questions, what you own and what it's worth, if that's valuable to you, now we need to figure out what documents do you actually need. These are not all of the possible estate planning documents, but they are some of the most common, and we're going to go through each of them today. Excuse me. I will also say that the documents that you might need may differ depending on where you are in life and what your situation looks like. So starting with the most common document, and the document that I think everyone over the age of 18 should have in place, we're going to start with wills. A will is a legal document that provides instructions for what you would like to have happen to your property when you die. It's also the place where parents can name a guardian for minor children. Now, you'll see on the slide, it says that you would include most of your property in a will. And that's because there are some types of property where the beneficiary or the person who benefits from it is named at the moment you get the property. And a perfect example of that is life insurance. When you purchase a life insurance policy, you, in that policy, name the beneficiary to that policy. And so when you pass away, the people you have named, the person or people you have named, will get a distribution from that life insurance policy. So that policy isn't something that you would also include in your will. Similarly, with a retirement plan, the beneficiary of that will be named in the plan. And then there are some pieces of property that have a legal standing called jointly owned with right of survivorship. And the most common example of that in most places in this country are homes. So if for example, a couple purchases a home together, they're both on the deed to the home or the title to the home, and it is purchased with a right of survivorship. What that means is if partner A passes away, all of the home goes to partner B. And so that legal standard is, again, very common with homes, but it's also seen in some other types of property as well. And because the decision is made when you purchase the property, who gets it next, you wouldn't include it in a will, except for the contingency if both of those people were to pass away, there's no more right of survivorship, who does it go to next? And so again, a very common example of that is husband and wife buy a house together, they both pass away in an accident, but they've included this house in their will to go to their child. It's a very common way to deal with these types of property. There are different types of wills, and some of these may or may not exist in your state. One of the things that is tricky about talking to a mixed audience about estate planning is that estate planning is an area of law that is very specific to each state. I will point you to places on the Triage Cancer website where you can find more specifics about what is required in your state. I will say that most states do require that wills be in writing versus like saying it out loud. Some states will allow it to be handwritten. Some states require that it needs to be typed. Some have what's referred to as a statutory will, where it's like a form and you have a fill in the blank situation. There are several do-it-yourself options online. There are both free options and there are options that you pay for. these that I've listed are just some examples of that. And then, of course, someone could go to an estate planning attorney barred in their state to have a will prepared. Now, I do not think that hiring a lawyer is necessary for many people, particularly if you have a pretty straightforward estate. So you are just naming a guardian for a minor child and you have one home. Those are the types of wills where these online services can be incredibly useful. However, of course, there are some benefits to hiring a lawyer, particularly if someone has a complex estate or if they potentially have property in multiple states or they're just concerned about making mistakes. Lawyers can be really helpful in that sense. I also think that another benefit to hiring a lawyer is that they can often make suggestions about how to craft an estate plan that could save money or could protect minor children. So I sit on both sides of this fence in that I don't think that not being able to hire a lawyer should ever be a barrier to creating an estate plan. That being said, for some people, hiring a lawyer can be incredibly helpful. When you are creating a will, there are some decisions that you're going to need to make. And the very first decision is who are the beneficiaries, which is really just a term for who's going to benefit from this will. Beneficiaries named can be really very general, or it can be super specific, or it can be a combination thereof. So I've given you an example here of general. Leave everything I own to my only child. Or specific. I want my cousin to get my record collection. I want my daughter to get my engagement ring. And then the mix is somewhere in between. So, I want these three people to get these three specific things. Everything else should get divvied up evenly among my two children. The other thing about creating a will and naming beneficiaries is they don't necessarily have to be people. So many institutions like universities or research facilities have the ability for people to leave a lasting gift in their will. Charitable organizations and nonprofits have something similar. And so people can really have a combination of all of these together. And a common thing to do is to create a charitable remainder in your trust, or in your will. So you could say, leave all my money to my child, leave my record collection to my cousin, and sell my house, and the proceeds would go to this charity. So we actually have no idea how much the house is going to sell for at that time, but whatever it does would go to the charity. So if you want to have a very complex situation like this, again, that might be an opportunity to hire a lawyer. Once you've decided who the beneficiaries are, if you have minor children or dependents, so for example, even if you have an adult child that maybe has a disability and might need looking after well into adulthood, you could name a guardian for those individuals in your will. We just this week released a new checklist called Planning Ahead for Minor Children, and it details some of the thought process behind how to pick a guardian. There's a worksheet on the back. It's incredibly useful, and I've given you the link here. Once we've thought about the beneficiaries and potential guardians, we next need to figure out who's going to be the executor of the estate. Now, when we're thinking about an executor, it certainly could be a spouse or a friend or a family member. Many banks provide this service for a fee. Similarly, attorneys might provide this service for a fee. If you do choose a friend or a family member, you might also want to think about providing potential compensation to that family member for acting as an executor. And the reason for potentially doing that is that it's actually a lot of work to be an executor. So these are just some of the possible duties, but it's really the executor's job once someone passes away to get the will and the death certificate and to file the will in probate court, to start figuring out where all the assets are. Are there other entities that need to be notified, like life insurance accounts or the Social Security Administration, debtors? Certainly, they're going to be responsible for paying any ongoing expenses while the estate is in probate, and debts. It could even mean having to file one final tax return. So the reason I say if you're going to pick a friend or family, it might be worthwhile to leave a little something in your will for that person to compensate them for this work. Certainly not required, but something to think about. So once we've thought about, okay, these are my big picture feelings about who I want to benefit from my estate. If I have minor children or a dependent, these are the guardians. This is the person I trust to actually do the work to execute my will. Now I'm ready to actually create the will. And every state has different rules about how you would create a valid will. So it is imperative that before you do this process, you look to your state's rules. But I will say at a minimum, in most states, it again requires the will be in writing, that you, who the legal name of the person writing the will is the testator, but it's the person creating the will, has to be at least 18 years old and of sound mind. Sound mind is a legal standard for making sure that the person who's writing the will still understands what it is that they are creating. And where this comes into play, unfortunately, is sometimes people will come to us and say, you know, my grandmother isn't doing well and doesn't have an estate plan. And we, as a family, we want her to create one. And so then the issue is, well, you know, is the grandmother still aware of everything that's going on and really understanding what it is that she's creating? And if the answer is no, it creates some legal challenges. Once the will has been drafted, it typically has to be signed and dated by you and then witnessed by two uninterested people. And so what that means is your witnesses, the people who are watching you sign and are basically attesting to the fact that you are of sound mind and it seems that you understand what it is you're signing. Those witnesses should not be people who benefit from the will. So if you're leaving everything to your best friend should not be a witness. So who could be a witness? I've had my neighbors be witnesses. I've had my coworkers be witnesses. So really it can be anyone. You are theoretically these people are never gonna have to do anything with this will again, unless it's contested in court. But if your witness is somebody named in the will, it can cause problems for that person and they may not be able to get what you have left them. Now, it is valuable to remember that wills can be revoked or changed at any time as long as you are still of sound mind. The way that you change a will is by creating something called a codicil. And a codicil is a legal document that amends or changes rather than replaces a previously executed will and is really helpful for minor changes. So it could mean things like adding or removing a particular gift or updating the legal name of someone who's gotten married and now has, you know, a different name. It could be that you are, So if you are creating a codicil for a minor change, that codicil has to be executed the same way a will is. So if in your state it says there has to be two witnesses that sign in the presence of the testator, that is the same rule for how a codicil has to be created. And codicils are incredibly important because you can't just cross something out in a will and add in a new name, right? So you can't say, oh, well, Brandon irritated me. I no longer want Brandon to get anything. Instead, I want it all to go to Sue. That's actually not going to be considered a legal change unless it's created through a codicil. If you have major changes, like completely removing somebody or adding a new child or grandchild, it's typically useful to create an entirely new will. If you do that, the general rule of thumb is to destroy any previous versions, because you don't want there to be a question of which is the valid will. For people who are dead set on keeping some sort of paper trail, then make sure, in big letters across the pages of an old will that you're writing, revoked or not valid or something, so that it just is super clear which is the valid will. It can also be really useful if you are moving states to have any existing estate planning documents reviewed by an attorney. Because, as I've mentioned several times, the rules are so different in different states. It can be really helpful if you are going to now permanently be living in a new state to make sure that the documents that you have in place are valid for that state. So what happens if you don't have a will? The process by which the provisions in your will are carried out after you die is known as probate. And even if you have a will, the will does have to go through probate. And there are different types of probate in different states. Some are more formal, some are pretty low key, and it's really just paperwork. But essentially, it's the process where your will gets submitted to a court. The court says, yes, this seems to be a valid will. Creditors are allowed to come and collect the money that you owed them. Similarly, this is the opportunity if people have owed you money for your estate to collect that money. And then the court says to the executor, go ahead and distribute the property based on what's in the will. So that happens even if you have a will, but it is usually much more straightforward than if you don't have a will. If you don't have a will, then your estate still goes through probate, and it is going to be much more complicated. It's going to be more expensive because now the estate has to pay for court fees and attorney fees. It is going to take a very long time. A year is on sort of the shorter end of that process. And there is no choice as to how the property gets distributed. Every state has what's called an intestate succession statute. Say that 5 times fast. But basically, it's a law that outlines which family members are going to get what. And it's every state's a little bit different, but it's typically the closest family member in a particular order. And based on those family members, it'll get divvied up. And so if you have a surviving sibling that you don't get along with, and that's your only surviving family member, and you pass away without a will, that sibling gets everything. And so really, it goes back to that very first piece that I was talking about with what are the benefits to an estate plan? Well, it's making sure that your wishes are carried out. And so, well, again, it's challenging and one more thing to do on the to-do list, creating that will can be incredibly valuable. So this slide really just kind of outlines the to-do list involved in creating a will. This is also included in many of our estate planning toolkits that we have that I will talk about in a little bit. So don't feel like you have to rush to write all this down. Moving on from wills, I want to talk about trusts. A trust is another estate planning tool. And unlike with a will that is expressing what you want to have happen to your property after you die, a trust is a legal entity that actually owns the property you place in the trust. There are terms here and they're like these big words and it can get a little bit confusing, but essentially the three most important terms are the person who is placing the property into the trust is known as the grantor. The person the grantor chooses to oversee the trust is known as the trustee. And then finally, the person who receives the benefit of the trust is known as the beneficiary. So to set up a trust, the grantor is going to list the purpose of the trust and makes the trust property available to the trust. Now, what is so different between a trust and a will is that with the will, you still own all your property. You're just saying that when I die, this is who I want to get my property. With the trust, you're actually, for lack of a better phrase, signing over your ownership of a property into the trust itself. Then the trustee has the legal responsibility to handle the property within that trust the way that you've asked them to for the benefit of the beneficiaries. Now, there are certainly pros and advantages to creating trusts. So there's control. So it could allow you to provide, or excuse me, it could allow you to include like specific provisions and exert more control as to when distributions might be made. So a common one is like, Kevin says his daughter only receives her portion of the trust if she gets a college degree by the age of 26. There are also some protection pieces involved here. So for people who might not be great at managing money, they could set up a trust for their benefit so they only get a certain amount of money for living expenses rather than a lump sum. There are also some privacy and probate benefits to creating a trust, which can also reduce court fees, and it keeps it private because probate's a matter of public record. And so all of that information, if somebody was looking for it, would be publicly available. There are many different types of trusts. These are just some examples. One of the most common types of trusts is often referred to as a living trust. And it's the most common because it is the most flexible. And typically in a living trust, the grantor, the person creating the trust and signing over their property, is also the trustee. So it means you're signing over the property to be in the name of the trust, but you as the trustee still have control over what happens with all of that until you pass away. There's another type of trust that could be very, very helpful for individuals who have a disability or a very serious medical condition. And those are called special needs trusts, also sometimes known as supplemental needs trusts. And what these trusts do is it allows someone to put assets into this trust for their benefit. And then those assets are not counted as assets for government programs that are based on income and resource levels. So programs like SSI or Medicaid or Section 8 housing, or even food stamps. And so again, this is really, really helpful for people who might have some assets like a savings account, but have no other income and aren't able to work due to a serious medical illness like cancer. They can create a special needs trust so that money that they have goes into the trust. They can still draw on it for their living needs, but it doesn't preclude them from accessing these other programs. Certainly, there are requirements to establishing these special needs trusts, and there are different types. And so I've outlined a few of them here, but if you are interested in these trusts, there's more information on our website and more details about how to go about creating one of these trusts. Now, this is typically when we're in person that someone will say to me, well, if I have a will, do I also need a trust? And the answer is, it depends. There are absolutely pros and cons to creating trusts, certainly the legal protection and avoiding probate. If you're thinking about a special needs trust, getting access to government benefits. But there are also some challenges. And one of those challenges is that it's hard to figure out what kind of trust you might need. You are, in fact, giving up your ownership to property. And that's all mixed in with some pretty complicated state rules. And so for people who are considering trusts, if they aren't 100% sure that they're confident in what they are doing, I would suggest seeking out an attorney or using a service that is specific to creating trusts. And I've given you our quick guide that has some tips on how to find an attorney who is reputable. And then I've also given you another site that has sort of a DIY fill in the blank type option for creating a trust. But you do definitely want to make sure that you've done it correctly because you are giving up that ownership of the property. Let me just check the questions and see if there are some to look at before we head forward. Okay, so you said that most people don't need a lawyer, but then they should look at one if they move. So certainly somebody who has moved could start over from scratch and just use an online will resource service to create a totally new will for their new state. Absolutely. My suggestion about finding a lawyer is if you have a complex estate, instead of starting over, lawyers might charge less just to review existing documents. But then also it can make sure hiring a lawyer can ensure that what you've done the first time is accurate and valid. So I apologize if I wasn't clear. I do not think people need a lawyer to create a will. I think in some circumstances, if you are able to afford one, or if you are concerned about how you've created a will, that lawyers can be incredibly helpful. So my apologies for not being more clear about that. Okay. Can you speak about the difference between a trust and a will? And his name is co-trust. Okay, so a will is a document where you are saying, when I die, I want this to happen to my property. It is also where you will name any guardians for minor children. Wills don't go into effect until you pass away. A trust is a legal entity that will own the property you put into the trust. If you have a trust, you still need a will. And that's for a couple of reasons. One, if you have minor children, there is no other way to name a guardian except in a will. Two, there might be property that isn't worth including in a trust, but that you still want to pass down. So for example, if you want to make sure that the family photo albums go to the one sibling that you know is organized and will take care of them, that's something you're going to put on a will. You wouldn't put your family photos into a trust because the photos don't have legal ownership. So the things that go into a trust are things like accounts and stocks and bonds and property. And so even if you're thinking about a trust, you still need that will. You do not need to file a will with the court until somebody passes away. When somebody passes away, you will take the will and the death certificate to the court, the probate court, and file at that point? They're great questions. Okay, keep them coming. Happy to keep answering as they come up. Switching gears a little bit, I'd like you to meet Frank. Frank received a call last night that his brother, John, had been in an accident and was unconscious at the hospital. Frank is his only living relative. Although John is breathing on his own, the doctors aren't sure if he's ever going to wake up, and he's going to need artificial hydration and nutrition very soon to survive. John does not have any documents in place, but Frank remembers hearing John mention once that he would never want to be in a vegetative state, as their mother had been years earlier. The doctors want Frank to approve or reject the artificial hydration and nutrition, and Frank is devastated about the possibility of losing his brother and is racked with guilt at the thought of, quote unquote, pulling the plug. This is a pretty common scenario. And the good news is that there are some documents that we can create to help make this situation a little less stressful. And those documents are called the Advanced Healthcare Directives. Advanced Healthcare Directives are a legally binding form that you fill out, you sign and date, and typically you get witnessed. So it's very similar to creating a will. Of course, every state has their own advanced healthcare directive. We have downloadable forms for every state on our state resources page. And in those documents, it details each state's requirements. Advanced healthcare directives are fully revocable, which means that you can tear them up, you can change them, you can revoke them at any point in time. There are different parts to advanced healthcare directives, and many of these parts get confused for each other. So advanced healthcare directive is the umbrella of what we're talking about. Under that umbrella, there is a portion called the instructions for healthcare. This part is often called a living will, which, while I recognize it's a common term, is a little bit confusing for people. A living will allows you to express your wishes for your medical care. Generally, it's going to be for narrow circumstances and only applies to life-prolonging procedures if you're unable to make your own healthcare decisions. So it could be things like providing food and water or blood transfusions or antibiotics. For some states, there is a list and your choices are give me all of them, give me none of them, or give me some of them. Other states on their forms are more specific and detailed. And they actually outline differences between something that might be considered a terminal condition versus something that is an irreversible condition. And do people have different feelings based on that? Still, some other states may also have an option to include additional requests. So are there particular treatments that you do or don't want? Do you want to have treatment in a specific location depending on circumstances? Do you or don't you want to donate your organs or have an autopsy? And what are your burial wishes? So all of this is, again, dependent on the state, but these are the types of things that are going to potentially be included in your directions for healthcare. One of the challenges when people are writing these additional requests is that it can seem to you that what you have written is very clear, but it may not be clear to your healthcare team. So for example, Martha's directive includes pain management, extraordinary measures, and no cremation. Well, if I'm a healthcare provider and I'm reading this, I'm very clear on the fact that she doesn't want to be cremated, but what does she mean by extraordinary measures? And does she or doesn't she want the pain management? So this is really just to point out that if you are going to write specific details in your instructions, be as clear as possible, even if you feel like you're going overboard a little bit. So I would, for example, instead write something to the effect of ensure adequate pain management. I do not want to be in pain. Avoid extraordinary measures. For example, artificial hydration or being resuscitated more than 3 times, or, whatever the thing is. So really, it's just about making sure that you're as clear as possible if you are writing these additional requests. So that's part 1, your instructions. Part 2 is known as the power of attorney for healthcare. And this is where you name an individual to make medical decisions for you. Again, called different things in different places. It could be your power of attorney for healthcare. It could be an agent. It could be your healthcare proxy. It's all the same thing. You are naming a person to make decisions for you about your medical care if you can't. And these are some of the decisions that they can make on your behalf. Now, the interesting thing about advanced healthcare directives is you could just have part 1 where you provide all the instructions right there. You could have just part 2 where all you're going to do is name an agent and say, you know what, if I'm ever unable to make decisions, they get to make every decision. Or you could have both. And having both is really helpful for this reason. Including your instructions provides some guidance to your agent about how you feel about certain things. It also allows you to have control and to feel secure that if there are certain things you feel really strongly about, like for example, Martha did not want to be cremated, that is 100% clear, but then her agent could make other types of decisions. It's also useful because I tend to find people, there are few things that they feel really strongly about. For example, I want my organs to be donated, but I don't want to be a medical school cadaver. So that's kind of strange, I guess, to some people. And so that's written in my instructions, but then my agent has the ability to make other organ donation decisions for me. When you're thinking about agents, it really can be anybody, except someone who's a minor or people who are part of your healthcare team. So they really want to make sure that it's sort of a person that has no other vested interest into what happens with your medical care. Now, here Sophia created a designation of a healthcare agent, and she says, I, Sophia Williams, appoint Charlotte and Jane Williams, blah, 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 to be my agent. Here's an issue. You never want to appoint co-agents, because what happens if Charlotte and Jane disagree on a decision? And if you think this doesn't happen, you'd be surprised to learn that it happens all the time, and these cases often end up in court. One of the most famous examples is the Terry Schiavo case. So it's really beneficial to name alternate agents, particularly if one agent is unavailable or perhaps dies before you, and you haven't updated your paperwork. There's another person there they can go to. So naming alternate agents, as many as you want, great idea, put them in order. Naming co-agents, not a good idea. Now, of course, there are some limits on what agents can or can't do. There are some legal limits. So for example, an agent couldn't authorize voluntary inpatient services or psychosurgery or abortion. There are also limitations based on what you include in those written instructions. And I've also heard from people that it was very helpful for them people who were agents, that it was very helpful for them that their loved ones included certain things in their instructions because they didn't feel the same level of guilt making certain decisions because they knew that that was what their loved one wanted because that's what they wrote in their document. And so while it's useful for you to have what you want have happen, it's also, again, a very loving thing to do to make sure that someone isn't feeling guilty for making a decision that you would have wanted them to make. Now, here again is Sophia's power of attorney for healthcare, and they've limited the decision-making authority of the agent. But this is another example where it's actually really challenging to understand exactly what Sophia wanted. So does she want the embryonic stem cells? Does she want the blood transfusions, or doesn't she? She's limiting the agent's power, but it's not entirely clear here. So if you are going to add additional limitations on your agent's power, make sure it's very, very clear which way you would want that to go. Also included in many advanced healthcare directives are some other instructions. So there might be instructions around resuscitation or organ donation, final disposition of your body could also be potentially included in here. Many people after a cancer diagnosis will ask if they're still able to donate organs. And while they're probably not going to be able to donate to a live recipient, there are many opportunities to donate to research. And so if that's something that speaks to you and is of value to you, know that there are those options. And then just like with wills, you typically have to sign, date, and have witnesses to these advanced healthcare directives. And you'll see there are limits on who the witnesses can be again here. Now, even if you have named an agent or if you are married, the people who you hope to have access to your medical records in order to be able to make these types of medical decisions may actually have a hard time accessing that information. And so in addition to an advanced healthcare directive, it may be useful to complete a HIPAA release form. These are definitely unique to each state. They're called different things in different states, authorization forms, release forms. But really what this does is it allows the people you have named on this form to have access to your medical records and information. And absent these, if you're over the age of 18, it can actually be very hard for even a parent or a child or a spouse to access your medical records. And the reason for that is our medical records really are supposed to be private unless we make that decision. So including one of these release forms along with your advanced healthcare directive can be very helpful. Another type of document that is worth considering based on one's situation is the physician's order for life-sustaining treatment, better known as the POLST form. These are medical orders that are completed by an individual who is seriously ill and towards the end of life. And these forms are signed by their physician. These forms are really only appropriate for people who are in what they think to be their final year of life or suffering from an advanced stage terminal illness or something that they're just not expected to recover from. They're not a substitute for an advanced healthcare directive. They are in addition to an advanced healthcare directive. It's sort of like a prescription from your doctor, ensuring that in the case of an emergency, you get the treatment that you want. So your doctor will fill out the form based on the contents of your advance directive and the conversations that you have with them based on your illness and your treatment. Once completed, these forms that are almost always these bright pink or orange colored forms are typically kept somewhere very visible. So if somebody is bound to their beds towards the end of life, it would be like taped up on the fridge or next to the nightstand, somewhere where if first responders were contacted and came, the first responders could see these forms and then provide services based on what is included in those forms. Another topic that comes up pretty frequently is death with dignity or physician-assisted death. Lots of different names for pretty much the same concept. And of course, there are very wide-ranging opinions about this, but generally speaking, death with dignity laws are about allowing individuals who are mentally competent adults who are terminally ill to obtain medication legally so that they can die on their own terms. And this, of course, is a state by state situation. And we have a chart of state laws that includes the states that have death with dignity laws. There's also a nonprofit called Death with Dignity that is engaging in advocacy efforts to expand the number of states that provide these services legally. Again, this is not advocating for or against, but it is empowering individuals that if this is something that they are interested in, there may be an option in their state to benefit from that. So we've talked a lot about healthcare, but what about financial affairs if somebody is incapacitated? A power of attorney for financial affairs is a legal document where you can name a trusted adult as your agent to make financial decisions on your behalf. And so these kinds of decisions could be things like accessing bank accounts and paying bills, even paying your medical bills. It could be about selling property. It could really be anything that isn't healthcare related. There are two main types of power of attorneys for financial affairs: durable and springing, otherwise known as standing and springing. So a durable power of attorney goes into effect as soon as you sign it. This can be really helpful, particularly if somebody is maybe, I don't know, going into surgery and they're concerned about what might happen while they're incapacitated. The more common one, to be honest, is a springing, which is something that you would create just in case something were to happen, like you got in a car accident, and it doesn't take effect until you're incapacitated. There's no specific end date in a power of attorney, but it does end the moment you die. So many people will be like, oh, I have a power of attorney for financial affairs, so I don't need a will. Like that person will just handle all of my affairs. But that power of that agent ends the moment you die. And that's why having the will or the trust, or the will and the trust, is so important. Now, if someone has not completed a power of attorney form and becomes incapacitated, it might be that a court gets to decide who is going to oversee your financial and medical affairs. And this is often called a conservatorship. There are conservators of the person and then conservators of the estate. So typically of the person, they're going to deal with health and well-being issues. A state is going to deal with financial issues. The court may name one conservator. They may name two, one for each of these things. And this person that gets named conservator could be a perfect stranger. And so when people say to me, this is so hard to talk about, this is so depressing, I don't want to do this, what's the harm in not having an estate plan? What I often say to them is, do you want a perfect stranger making your medical and financial decisions for you? And if the answer is no, then creating the estate plan is definitely the way to go. Now, a lot of estate planning boils down to the idea of leaving a legacy, protecting your loved ones financially. But I would argue that your legacy isn't just about your assets or the things that you own, but you may also want to make sure you pass down other things that you find valuable. So that's where these non-legal tools can be useful. I put wills here in quotes because what we're talking about is not legally binding. It cannot be used as a substitute for a will, but rather these are tools to pass things down like memories, lessons, words of wisdom, sacred beliefs down to your loved ones. They can be incredibly useful, again, for that legacy purpose, but also maybe as a way to explain your thought process and intentions to future generations. So here's an example of what I mean. Let's say you're a grandparent and you're creating a trust for your newborn grandchild. And in that trust, you have created a stipulation that says, in order for that grandchild to get anything out of the trust, they have to pursue an advanced degree. Well, without any sort of discussion or information, that grandchild might grow up and actually be a little bit resentful of having to do this in order to benefit from the trust. However, a legacy letter could be left explaining your thought process. Maybe getting an advanced degree was something that was on your bucket list and you always regretted not doing it, but you didn't for whatever reasons. And this is why you want to make sure that your grandchild has that ability to do so. Explaining that thought process may go a long way to helping future generations. And of course, these are all just examples that I'm coming up, and there's lots of different reasons why someone might want to create sort of a legacy letter or an ethical will. Now, certainly these documents could be something written, but they could also be a voice recording or a video recording or a film. And I sort of think of these things as like some sort of hybrid between a memoir and a directive. They're not required, but they are a useful tool in the larger estate planning process. So I've said a few times today that I recognize how emotional it can be to create an estate plan. And so I just want to mention that there are some entities that may be helpful as you embark on your estate planning. So perhaps it's one of your religious leaders, or perhaps it's an actual mental health care professional. It could be someone on an oncology team that you want to talk to about, medical things that might come up if you're creating an estate plan. Or maybe you need to talk to a therapist about, how you're feeling, or to bring your family into how you're feeling. And so I just wanted to kind of bring up that while these legal documents are incredibly important, the emotional support is equally important. Once you create this estate plan, there are some more practical pieces that could be valuable. So certainly having conversation with your loved ones about your decisions, I think, can save a lot of future angst and challenges. Also thinking about who might need access to the things that you own, particularly the things that come up sort of on a routine basis at Triage Cancer, is like people don't have access to safety deposit boxes or storage units or bank accounts of their loved ones who have passed away. And sure, you can go to court, you can get a court order with the death certificate, but those things take time and money, and they just add to the stress level. And so if you know you have an executor that you want to access these things once you pass away, make sure they're listed on the safety deposit box. Make sure they're, allowed to access the storage unit by just showing your death certificate. Another thing that I don't think gets talked enough about are our electronic property. So as more and more of us are living more and more of our lives online, it's useful to think about, well, what do you want to have happen to your email or your social media accounts? Now, some of us might think, great, once I pass away, I never want to think about my inbox again. But think about this. A lot of our emails are also attached to online storage systems. And personally, I have every photo from the last 7 years online. And so when I die, what do I want to have happen to those photos? The social media accounts are similar. So different platforms have different rules on how to go about dealing with them. So Facebook allows you to name a legacy contact who then has the ability to convert your page into a memorial page or to take it down entirely. Gmail has someone that you can list right now to be, your account manager. So it's just really thinking sort of outside the box of what we traditionally think of as property and making a plan for those things. It may also be really useful to think about funeral planning. If you want a funeral or a celebration, what does that look like for you? If you are planning on being cremated or buried, those are things that have a substantial cost associated with them. And we hear from a lot of people that it creates some problems when people haven't planned ahead. And so there are a couple different ways to plan ahead. There's insurance that you can purchase. You can actually, if you, for example, want to be buried, you can go to a funeral home and pre-plan and prepay for those services. I know someone who was adamant that he wanted it to be a celebration and not something sad. And he planned the whole party down to the bagpipes that were going to get played. And he said to me that it actually was very healing for him to do that because he also knew that not only was he going to get what he wanted, but that he wasn't putting that extra burden on his family. There are also some services that may allow you to pre-plan for messages that you want to share. And so if you want to pre-plan presents or birthday cards or a memorial video, they will allow you to do that. And again, we've just given you some examples here. Once you've planned your estates, what do you do with all the documents? It really depends. It is incredibly valuable to try to collect all of this information into 1 or 2 places and keep it up to date. So make sure that you have a list of current assets, including accounts and login information, what bills need to get paid, where are the keys to things, and then certainly all the documents that we've talked about. Now, there are many ways to store these documents. A low-tech way is to kind of give photocopies to your agent or to a family member, or have your advanced healthcare directive filed at your hospital. The downside of that is it becomes harder over time to make sure that everybody who needs updated copies gets it and there aren't old copies floating around. So an alternative is to save an electronic version of some of these documents. So there are services that you can pay for, like Master Lock Vault, but there's a lot of free options too. I personally use Google Drive, where you can send a link to people so they can access whatever documents are in that drive. And they can access it from anywhere in the world as long as they have a Wi-Fi connection. And that way it also allows me to know that's the one place where I need to go and update documents. And I can ensure that no matter what, people always have access to the latest document. If you don't feel good about that, you could certainly just even email them to yourself and your agent so that they would have them in their email if they needed them. So this is really just sort of a wrap up. And as I talk about the next couple of things, again, please feel free to type your questions in the chat box. I'm happy to take questions towards the end. Creating an estate plan is definitely not a one-size-fits-all situation. I hope I've given you examples of how different an estate plan might look from one person to another, but it is definitely an ongoing chore, so to speak. It's really valuable to review your estate plan periodically to look for, are there changes in your family? Have new babies been born? Have people passed away? Have assets changed? So if you planned it so that your two children got equal things, but then maybe you sold property since you first created that, you might need to change that. It may also be that where you are in life, your wishes and your beliefs have changed since when you last created an estate plan. Certainly, again, cannot stress this enough. We hear horror stories. Make sure that somebody, hopefully your executor, knows where your plan is located. And then make sure that you discuss your plan with everybody involved. You don't want your agent to first learn that they have been named your agent when they get a call in the middle of the night saying that you're in a coma and they have to make a decision about your healthcare. Really, you should be asking these people if they're willing to serve as these roles before it ever becomes a thing. So I see some questions ticking in, but I want to make sure I get to some new resources that we have around estate planning. We are very proud to announce that a new resource created in partnership with Eisai Pharmaceuticals and Cancer Care called Magnolia Purpose in Planning was launched today. This is an online resource that was designed to try to help you take next steps in your planning process. And it includes many of Triage Cancer's existing resources on estate planning. And I've mentioned a few of these already as I've gone through, but I really want to highlight the 3 animated videos at the bottom. These are, I think, a great starting point for people who are potentially reluctant to think about estate planning. Again, they are available in English and Spanish, and they have closed captioning. We also have another new resources hot off the presses, which are our state-specific estate planning toolkits. So this toolkit talks in great detail about many of the topics I've talked about today, but it also provides state-specific information, so you can download your state's information, and it includes any state-specific forms that might exist. And so I definitely encourage you to check that out.